Yeah, is everybody about ready?
Yeah.
From y'all's side?
The official heads up?
I think we're getting close. Y'all know this stuff better than I do, but is this about in terms of where y'all like microphones? Is that close enough?
Yes, sir.
Okay.
Whoever's talking about your right?
Yeah.
Do you know who the speaker will be? Can you tell us that?
I'm not going to answer the questions.
No, we just want a good speaker so we can let people back to our station.
I think that for this attorney.
What's his name?
It's Corey or Evans.
Yes, sir.
Good afternoon. Thank you for coming. My name is Corey Amundsen. I'm the acting United States Attorney in the Middle District of Louisiana, where I've served as a career federal prosecutor for the last 15 years. I'm joined here today with Robert Musi, who's a 22-year career federal prosecutor who serves as the senior career official with the Civil Rights Division of the United States Department of Justice. I'm also joined by Tamara Kessler, who is also with the U.S. Department of Justice's Civil Rights Division and has been a career prosecutor for 28 years and serves as chief of that division. In addition, I'm joined by Jeff Sillett, the special agent in charge of the FBI New Orleans Division and also the former chief of the FBI's National Civil Rights Section. In addition, I am joined by Ron Reed, who leads the FBI's Civil Rights Section in the New Orleans Division. We are career public servants who have been in service to the Department of Justice in capacities as prosecutors and agents for more than 70 years. Following the fatal shooting of Alton Sterling last July, and in response to requests by the community and state and local officials, our offices together commenced an extensive and thorough federal criminal investigation into the circumstances surrounding the shooting. This morning, I'd like to discuss with you the investigation, the approach we took to review this tragic situation, as well as our decision and the reasons for it. After an exhaustive, almost year-long investigation, all of the prosecutors and agents involved in this case have come to the conclusion that insufficient evidence exists to charge either officer with a federal crime in connection with this incident. A short while ago, we met with Mr. Sterling's family. We expressed our condolences for the loss of their nephew, father, and their children's father. We also shared our findings and decision with them. In addition, we informed the officers through their attorneys of our decision. We don't normally publicly announce the declination of charges in a matter, particularly in a situation like this, where there will be a state investigation to follow. But we simply felt that making a public statement was the right thing to do in a case that meant so much to so many. However, we must still be careful not to impede or jeopardize the integrity of the state investigation and decision process. To do that, this briefing will be limited to this statement. We hope that the information provided in my statement, along with a detailed press release to follow, will answer any questions you may have. Our investigation focused on one question. Did either Officer Salamone or Officer Lake violate federal criminal civil rights laws or any other federal criminal law in connection with their encounter with Mr. Sterling? As explained in more detail in our press release, federal law makes it a crime for a police officer acting willfully to deprive an individual of their constitutional rights. To prove that a shooting, such as here, violated Mr. Sterling's rights under federal law, the government, us, we must establish beyond a reasonable doubt that the officer's use of force was objectively unreasonable based on the circumstances at the time and based on their perceptions at the time. The government would also have to prove beyond a reasonable doubt that the officers acted willfully. That is, that they acted with a specific intent to do something that the law forbids. Under this standard, it is not enough to show that an officer acted recklessly or with negligence or by mistake, exercised bad judgment, used poor tactics, or even that the officer escalated the situation where he could have de-escalated it. Those things are not violations of the federal criminal civil rights laws. Federal prosecutors are only allowed to bring federal criminal charges if we believe we could establish the defendant's guilt beyond a reasonable doubt at trial. That is the Department of Justice policy, and that is the ethical rules that bind us. These rules apply to every single federal criminal case and every federal prosecutor in the country. So with this rule and with the law in mind, we began our investigation shortly after the shooting. My office, along with the Civil Rights Division and the FBI, assigned very experienced senior career prosecutors and agents who worked on this matter nearly full-time through many nights, weekends, and holidays. We also enlisted support from literally dozens of team members, including personnel from the FBI lab in Quantico. Our aim was to determine the facts as best we could through an exceedingly thorough and comprehensive investigation. We promised that when the investigation began, and we thought it was the right thing to do by Mr. Sterling's family, the officers involved, the police department, and this community. One agent actually remarked that we would not only leave no stone unturned, but after we turned over each stone, we would just keep digging and find whatever was underneath. And that's exactly what we did. The team probed and questioned dozens of witnesses, from government employees to civilians. We obtained, reviewed, and enhanced numerous videos that captured all or part of the incident and the periods before and after, including cell phone videos, store surveillance video, police vehicle video, and videos from body cams. We examined how evidence was collected and analyzed. We hired national use of force experts, and we obtained and reviewed voluminous documents and records, including BRPD records, policies, training manuals, personnel records, and other documents. We took nothing for granted. We followed any trail of evidence that we thought had any possibility of shedding light on the officer's state of mind and intent at the time of the shooting. In addition to the shooting itself, we gathered evidence concerning the officer's activities before and after the shooting to determine whether any of that activity may have violated federal criminal laws, including the federal civil rights laws, as well as the laws against false statements and obstruction of justice. Again, we assumed nothing. Some of the additional investigative steps that we took did add to the length of this investigation, but we believed it was most important to ensure that the investigation was complete and accurate. Also, while understanding of the interest, the tremendous interest in this investigation, we firmly believed that any premature public discussions and disclosures about the investigation would risk its accuracy and its reliability. That simply was unacceptable because our goal was to ensure the most accurate and complete results. So let's now turn to the facts. It is important to note that this entire exchange between Mr. Sterling and the officers happened very quickly, with events happening in rapid succession. The entire encounter, from the moment the officers first approached Mr. Sterling through the firing of the sixth and final shot, was about 90 seconds. Based on dispatch recordings, we know that at approximately 12:30 a.m. on July 5, 2016, Officers Salamone and Lake were told to respond by dispatch to a report that an African-American man wearing a red shirt and selling CDs had, quote, pulled a pistol on somebody outside the Triple S Food Mart and had a gun in his pocket. It is reasonable to expect officers with this information to focus on eliminating any threat from a gun immediately upon their arrival. The videos, which are disturbing, show that the officers arrived on the scene with an immediate goal of ensuring that Mr. Sterling's hands were in control and not able to access a weapon. At first, they directed Mr. Sterling to put his hands on the hood of the car. When he did not comply, the officers placed their hands on Mr. Sterling, who struggled with and resisted officers. Officer Salamone then pulled a gun and pointed it at Mr. Sterling's head, prompting Mr. Sterling, who appears confused at this point, to put his hands on the hood. Mr. Sterling's size, 6'3" and over 300 pounds, made it difficult for officers to control, much less handcuff Mr. Sterling at that point. After Mr. Sterling, still struggling, briefly attempted to move his hands from the hood, Officer Lake deployed his taser on Mr. Sterling, who fell to his knees, but then began to get back up. The officers ordered Mr. Sterling to get down, but Mr. Sterling did not comply, and Officer Lake attempted unsuccessfully to tase him again. At that point, as Mr. Sterling stood to face the officers with his hands free, Officer Salamone holstered his weapon and then tackled Mr. Sterling. They both went to the ground with Officer Salamone on top of Mr. Sterling, who was on his back with his right hand partially under the hood of the car. Officer Lake joined him on the ground, kneeling on Mr. Sterling's left arm, while Officer Salamone attempted to gain control over Mr. Sterling's right arm. Within a few seconds, we know from the audio and video that Officer Salamone yelled, quote, "Going for his pocket, he's got a gun, gun," or words to that effect. Officer Salamone did not shoot at this point. Instead, he was attempting to gain control of Mr. Sterling's hand, but we know from the video that he was not successful. Officer Lake drew his weapon and yelled at Mr. Sterling, again directing him not to move. Less than 1 second later, during a point at which the location of Mr. Sterling's right hand is not visible to the video and to the cameras, Officer Salamone again yelled that Mr. Sterling was, quote, "going for a gun." It is at that point that Officer Salamone then fired 3 shots into Mr. Sterling's chest. In order to convict Officer Salamone of a federal criminal civil rights violation for this shooting, we would have to prove beyond a reasonable doubt that Officer Salamone did not believe that Mr. Sterling was actually going for a gun when he made that statement, and that he simply decided to shoot him. Within a few seconds of the first 3 shots, as Officer Salamone and Mr. Sterling were both laying on the ground, Mr. Sterling began to sit up and roll to his left. With his back to the officers. At this point, the officers could not see Mr. Sterling and what he was doing with his hands and whether he was going for a gun. Officer Lake yelled at Mr. Sterling to get on the ground, and when Mr. Sterling continued to move, Officer Salamone fired 3 more shots into Mr. Sterling's back. Immediately after the shooting, video shows Officer Lake go directly to Mr. Sterling's right pocket and retrieve a .38 caliber revolver, which was loaded. In statements made immediately following the incident, both officers stated that they saw Mr. Sterling reaching for a gun and saw the gun itself coming out of the pocket. The struggle on the ground lasted a total of 27 seconds. As a result, life and death decisions were being made in split seconds. This is an unfortunate reality of police work at a time when encounters between the police and the community have been increasingly violent and unfortunately often deadly. In this case, we consulted with 2 independent use of force experts who the Civil Rights Division has previously engaged as government witnesses in other federal civil rights cases. Both experts are nationally recognized authorities in this field, and they are truly independent. Neither is from Baton Rouge area or has any ties to the Baton Rouge Police Department or the officers involved. Now, I want to be clear. Both experts criticized aspects of the officers' techniques and approach in this case. Having said that, the experts also concluded unanimously that the officers' actions were not unreasonable, and because of the quickly unfolding and dangerous circumstances, and therefore met constitutional standards. In the expert's opinion, the officers cycled up and down a use of force continuum in a manner reasonable when confronting an armed suspect before ultimately using lethal force, which they did not use until Officer Salamone shouted that Mr. Sterling was reaching for his gun. In light of all this, it was the unanimous decision of all of the prosecutors and agents in this case that we simply did not have sufficient evidence to prove beyond a reasonable doubt that either officer violated the federal criminal civil rights laws. As I said before, to prove a federal criminal civil rights violation, we have to prove beyond a reasonable doubt that the officers acted unreasonably and willfully. That is, that they acted with a specific intent to do something that the law forbid. This is the highest standard in federal criminal law, willfulness. Being reckless, escalating a situation that may have been de-escalated, those things are not a basis under the law for a federal criminal civil rights prosecution. First, we were unable to establish beyond a reasonable doubt the precise location of Mr. Sterling's hand at the moment at which the officer states on the recording that Mr. Sterling was, quote, going for a gun. In other words, we cannot establish that Mr. Sterling was not reaching for a gun, or more accurately, that the officers did not believe he was reaching for a gun. And therefore, we can't establish that the lethal force that was used was unreasonable. Second, as I mentioned earlier, there is a distinct statutory requirement of willfulness. In our view, the evidence is insufficient to meet this element because we cannot prove beyond a reasonable doubt that the officers knew what they were doing was unreasonable or prohibited, and they simply chose to do it anyway. There are no winners here, and there are no victories for anybody. A man has died, a father, a nephew has died. My heart goes out to the family. For the family, for the community, for the police department, and for the cause of justice, please know that experienced, highly trained federal agents and prosecutors worked hard to investigate and examine the facts to determine if a federal criminal case could be brought here. We have all concluded that no such case can be brought under federal law. Going forward, we will continue to support and work with the Department of Justice's Community Relations Service, which has been on the ground since this past summer, working to increase dialogue and engagement among civic and community leaders. And my office, which has long been involved in numerous community outreach projects and initiatives across Baton Rouge, will continue to look for opportunities to engage with citizens, students, lawyers, and others interested in federal criminal civil rights laws or any other federal criminal laws through healthy, productive dialogue. The United States Department of Justice, of which we are all a part, everyone up here, remains committed to investigating allegations of excessive force involving police officers or any other law enforcement agents. And we will continue to devote significant resources required to ensure that all serious allegations of civil rights violations are thoroughly examined. The Department aggressively prosecutes civil rights violations whenever there is sufficient evidence to do so, and in fact, there are investigations and prosecutions ongoing in this district as we speak between us and the Civil Rights Division and the FBI doing just that. Having said all of that, it is again based on the evidence of this particular case that we have all concluded, every single agent and prosecutor on this case, those standing up here and those not, that there simply is not sufficient evidence to proceed with a federal charge. The Louisiana Attorney General's Office, with the assistance of the Louisiana State Police, now intends to conduct its own inquiry into whether the conduct at issue violated any provision of the Louisiana state law. And it will have at its disposal every piece of evidence that the federal investigation has been able to obtain. Finally, I would like to discuss how we came to the decision to provide limited advance notice of today's announcement. Given the events following Mr. Sterling's death last summer, we worked with the governor, the mayor, and our state, parish, and local law enforcement heads to establish an agreed-upon notice procedure that would minimize public safety concerns. That is the procedure that was implemented today. I pray that God gives us, our community, the strength to rise above this tragedy and all the events that followed it, and that He enables us to listen to those different than ourselves so that we may all become better because of it. May God bless all those involved in this terrible tragedy, and God bless the resilient and great city of Baton Rouge.